The prosecution's first ground of appeal against Musliu is thus rejected. In its second ground of appeal, the prosecution submits that the trial chamber erroneously failed to find Musliu responsible as a commander pursuant to Article 7.3 of the statute. The prosecution argues that since the trial chamber found that Musliu exercised command and control over the Celico 3 unit, it would have also found that he exercised command and control over the KLA soldiers in the camp had it not failed to find that the Celico 3 unit was responsible for operating the prison camp. With regard to the role of the Celico 3 unit and its members in relation to the camp, the appeal chamber concludes that the prosecution does not show that the trial chamber found that the Celico 3 unit was the only KLA unit that was regularly stationed during the indictment period south of the Peć-Pristina main road where the prison camp was situated. The appeal chamber notes in this regard that the trial chamber found that the Pelumbi unit was stationed to the south of the prison camp for a time in July 98. The prosecution further submits that neither the Pelumbi unit nor outsiders to the camp could have operated the Lapušnik prison camp. The appeal chamber finds, however, that the prosecutors did not show that the operation of the camp had to be carried out by soldiers of a single specific KLA unit, such as Celico 3. Moreover, it could reasonably be inferred from the evidence that soldiers from the Pelumbi unit or from other KLA units in the vicinity of the prison camp participate in operating the camp. The appeal chamber further dismisses the prosecution's submission that the trial chamber neglected to consider circumstantial evidence in assessing whether the Celico 3 unit was responsible for operating the prison camp, as it is evident from the trial judgment that inferential or circumstantial evidence was in fact considered. Moreover, the appeal chamber is satisfied that the trial chamber did not apply an erroneously piecemeal approach to its assessment of the evidence relating to the proximity of Celico 3 to the prison camp as suggested by the prosecution. The prosecution makes the alternative submission that the trial chamber erred in failing to find that members of the Celico 3 unit participated in the operation of the camp. The prosecution specifically submits that the trial chamber erroneously failed to find that Bala and two prison guards named Tamuli and Salihi were members of the Celico 3 unit and that their involvement in the operation of the prison camp as members of this unit entailed the command responsibility of Musliu. The appeal chamber finds, however, that it was reasonable to infer from the evidence that these three guards were not members of the Celico 3 unit throughout the indictment period. As such, the appeal chamber is satisfied that it was a reasonable conclusion for the trial chamber not to find that soldiers of the Celico 3 unit participated in the operation of the prison camp. The appeal chamber is satisfied that the trial chamber did not err when it did not find that Isak Musliu incurred the criminal responsibility pursuant to Article 7.3 of the statute for crimes committed in the Lapušnik prison camp. The prosecution's second ground of appeal is thus rejected. Finally, in relation to the prosecution's third ground of appeal with respect to Musliu's alleged participation in a systemic joint criminal enterprise, the appeal chamber recalls its finding, Judge Chombo dissenting, that it was not the only reasonable inference from the evidence that Musliu participated in the operation of the prison camp. Thus, the appeal chamber finds that the prosecution's allegation under the third ground of appeal have already been disposed of. I will now read out the disposition of the appeal judgment. Mr. Bala, will you please rise This is the disposition. For the foregoing reasons, the Appeal Chamber, pursuant to Article 25 of the Statute and Rules 117 and 118 of the Rules of Procedure and Evidence, noting the respective written submissions of the parties and the arguments they presented at the hearing on 5 and 6 June 2007, sitting in open session, dismisses Haradin Bala's appeal in its entirety. Dismisses Judge Wolfgang Schomburg dissenting with respect to the prosecution's first ground of appeal in relation to Isak Musliu, the prosecution's appeal in its entirety. Affirms the sentence imposed by the trial chamber against Haradin Bala, subject to credit being given under Rule 101C of the rules for the period Haradin Bala has already spent in detention, and orders, in accordance with Rule 103C and Rule 107 of the rules, that Haradin Bala is to remain in the custody of the International Tribunal pending the finalization of arrangements for his transfer to the state in which his sentence will be served. Judge Mohammed Shahabuddin appends a declaration, and Judge Wolfgang Schomburg appends a partially dissenting and separate opinion and declaration. Mr. Bala, you can now sit down. Mr. Registrar, would you please distribute copies of the appeal judgment to the parties? Thank you very much. This concludes the appellate proceedings in this case. The appeal chamber will now rise.
All rise. Feu vous lever.